Well, good afternoon, everybody. Welcome to AFSA, on a beautiful fall afternoon. I'm Bob Silverman, the president of AFSA. I'm pleased to have everyone here and welcome you to the 10th installment of our ongoing speaker series on issues of personal interest to members of the Foreign Service. So far, over the last 2 years, we've covered such topics such as health insurance plans, Medicare, long-term care insurance, divorce, Social Security benefits, to name a few. Today, we're going to be hearing all about estate planning and specifically wills and trusts. In the future, we are planning a session on financial planning for retirement. And also, we welcome any feedback you might have on additional topics of interest to you. And where's Matthew Sumrek? He is in charge of this series. Thank you, Matthew. Or you can email me directly, and I will make sure it gets to the right folks. And we welcome your ideas for future topics. My email, by the way, is silverman@afsa.org. So I look forward to your feedback. Today, we are very pleased to welcome Jonathan Keeney and Lauren Keenan-Rote of the law firm Bean, Kenny, and Corman. They are both experts in estate planning, among other topics. They also do real estate and wealth management. John represents regional and national developers, real estate developers, property owners, business owners, in all aspects of land use and zoning law. He also works with nonprofit organizations on affordable housing projects. In addition, he regularly represents clients on matters involving property transactions, land use and zoning. Lauren focuses her practice also on land use and zoning, but also does estate planning and estate administration. As an estate planning attorney, Lauren assists clients with determining their estate planning needs, and she drafts all the documents tailored to those needs. I'll let them describe the details of estate planning. I remember that course from law school. It was a nightmare. So, particularly the rules of infinity and all. I'll describe it. There's some hoary topics there. I'm so glad they're here to talk about them. So we're very pleased to have both John and Lauren here with us today. So let's give them a round of applause.
Good afternoon. We're doing kind of a estate planning 101, but I want to make it clear from the very beginning, what we're also trying to do is answer your questions to the extent that we can. If you're embarrassed of asking your own question, it can be your Aunt Thelma in Omaha has the problem or something of that nature or had this question. So the whole idea, though, is to try to make it interactive for you and try to answer your questions. As we start out, we're basically going to talk about the different tools that are available to us in estate planning. Some of them are only effective during our lifetime, some of them are only effective after our death, effectively. But I'm just going to, I don't need to, oh, you need to keep pushing the button or something, right? Or I need to do it. Okay. Do I just need to do that, or is that not?
No, now it's working. Sorry.
Technology is not my friend. I don't need to go through all those. You can read them basically yourself, but I am going to talk about all of them. If we go to the next slide. The durable power of attorney is a document that I personally feel has become probably as important as the will itself. As we get older, as our ability to outlive our medical improvements have occurred that makes it possible for us to live a lot longer than maybe our mental competency or physical capabilities are. So what a durable power of attorney does, and I know for some of you this is going to be very basic, but for the others, I'll try to throw in some other things maybe of interest. It basically names an individual that is going to act in your behalf if you're unable, whether it's because of a coma, you could be overseas on assignment, you could be buying or selling a house while you're here. There's a number of possibilities that you could use a durable power of attorney for. It can be either effective immediately, which would be the normal situation, say, between a husband and wife, or it could be a springing power of attorney, which means it only takes effect after a certain event has occurred. Usually that's competency or somebody's in a coma or something like that. We generally, in most family situations, we would generally recommend having these documents effective immediately. You can ask the attorney or somebody else to hold them in their safe so that they're not necessarily going to be used in a divorce situation, which is probably not a concern of a lot of people in this room. Just looking at some of us have the white hair and others don't, but it is something you do think about. The springing power of attorney is a great document, but what we've found between husband and wives and spouses, significant others, is there's a great tendency or hesitancy to have people declared incompetent so that the event has occurred. People wait too long because it's psychologically not something that they want to do. So generally we recommend for a husband and wife type of situation or significant situation that we basically go with the currently effective document. But that's a personal choice. And while we discuss it with people, it's not, some people decide one thing, some decide another. What the power of attorney does is it basically avoids the court deciding or other family members deciding who is going to make decisions in your stead. So the requirements differ from state to state. Maryland, for example, has a fairly standard form that they encourage people to use. It's available on a number of websites and stuff like that. So if you're a Maryland resident, that may be something you want to consider. One of the questions that comes up is the enforceability of these power of attorneys, because what happens is the local banks often don't accept them. Has anybody had that experience where they've had a local bank not accept a power of attorney? Or no? Okay, well, too much about that. But in a number of cases, people have said the local banks just don't accept them. And so what the legislatures in a couple of the states around here have done is they put provisions in to require parties to accept power of attorneys. Virginia has enacted an act that basically says if you don't accept it, you have to give reasons why. If the person responds by certifying or translating the document to English or things of that nature, then you have to accept it. And if you don't accept it, there are penalties occurred. Now Maryland's even stronger. They basically say if you follow the form power of attorney, everybody has to accept it. And again, there are penalties if you don't. So probably, hopefully, we wouldn't have that problem. But on the other hand, when we talk to other groups, it's been a fairly common problem. Yes, sir.
If you're in a marital situation and you decide to make the durable power of attorney effective immediately, how difficult is it to revoke if you're
Revoke it at any time. You can revoke it either by tearing it up or terminating. And one of the things that's usually required by the party accepting a power of attorney, at least a bank or a title settlement company, is they usually would require an affidavit from the person signing on your behalf saying that they have no knowledge of the revocation. Now, does that give a full protection? No, but it is a fairly good protection. Obviously, if somebody did something without the permission of the other person, or the power of attorney is only supposed to be effective when you're unable to act. So as long as you're able to act, it should not be used. And if somebody uses it for that purpose, it's usually going to be thrown out. There's been a lot of litigation in this area recently, and courts are kind of coming down fairly consistently saying that you have to follow the purpose and the intent of the document. So, why don't we go to the next one?
Enforceability in DC.
Don't know. I don't know that there's a statute. We didn't see one particularly, so unless there's been some judicial case on it, maybe somebody has an answer to that.
Can
Yes.
I ask one more question about power of attorney?
Sure.
Yeah, so would it behoove you, would it behoove you to have a power of attorney written up in the state that the person is living in, who is the person who would be?
The power of attorney, mostly, the individual executing the power of attorney, best practice would be to execute that in the state where they live, not where the person who's going to have the power of attorney lives. But there are, it's certainly worth taking into consideration. For example, if you were living in another state, but you knew both of your power of attorneys were in Maryland and you were concerned about enforceability, then maybe I would go with a Maryland form document in that case. So that, again, general rule where the person themselves lives, but in some cases it is going to make sense to do a power of attorney, particularly when there's good statutory provisions protecting the enforceability of that agreement. The next document is an advanced medical directive or a living will. That is really a document in time that's intended to cover your own personal preferences. If you have a medical power of attorney, what that's doing is naming another individual, just like your regular power of attorney, to act in your behalf when you're not in the situation to do it. An advanced medical directive takes it another step and not only names the other individual, but it gives them guidance on certain issues like the use of oxygen, owner donation, pain management, things like that. And it basically is stating out what your wishes are in that regard. So if one of your relatives comes in and said, she would never have agreed to that or something, you can say, well, maybe she didn't when she was your sister in Omaha or something, but since then it's changed, and here's her advanced directive where she said X or Y. So, yes, sir.
I'm stepping back a minute, the medical directive. Why wouldn't that be already subsumed if you had a general power of attorney?
You can include the two together. Medical directives came in later. They really didn't start until around the 70s. So initially we started doing them as separate documents, and they've just kind of continued that way. I will say to you, in this area, in the DC metropolitan area, the need for a medical power of attorney is very low, quite honestly, because either the hospitals are going to have a form that they want you to sign before you go in for surgery, or they're going to follow the wishes of family members. In our experience, there are only a few areas of the country where you have any problems. You usually have religious organizations who may be running hospitals or something that may be contrary to the person's belief, and then there's a conflict of that nature. Or the very rare case, but the ones that certainly make the TV and newspapers are the Terry Schiavo type of case, where a politician decides that they know better than what the family or the individual wants, and then they get involved. So, excuse the political statement on that one. Yes, sir.
I would just say that there are some hospitals that do ask for a medical power of attorney.
No, okay.
They want to have a copy on file.
We still prepare them, we still urge people because you don't know where you're going to be. But in most cases, even if you don't have it, hospitals in this area are going to follow the directions given by the family unless you don't want that. In some areas, that's not necessarily the case because there are different, religious or social mores between the family and the hospital. But in this area, you don't find that as a general rule. No, we still recommend the document. We're just saying it's become over time, society has accepted these more and more, and they've kind of accepted the general. Most hospitals in this area have a chart that they go by on who in the family would make the decision if there are multiple people, like son, daughter, wife, significant, something like that. So in those cases where you don't want what the default rule might be, then definitely the power of attorney becomes very important. I mean, if you don't want somebody serving in that role that they would if you didn't name somebody else, then that becomes an important decision. But a lot of times in this area, the hospitals are just going to recognize family members without a power of attorney. I'm not suggesting that that's the best practice. I'm just kind of putting an aside that's what the practice is in this area. Go to the next one, and this really is the issue of titling property has become more of a factor in an estate plan than it was even 10 or 15, 20 years ago. Because these are situations that override the will. So people come in and they think, all right, I'm giving everything to Susie and John, and then they have their 403B or their 401K, or they have an insurance policy, and they give those to other individuals. And so the probate estate, the estate that's actually covered by the will, may only be 20% of your assets, and it's not necessarily what you intended. So let's go over just examples. Joint ownership. Obviously, people own property with a brother and sister, their spouse, significant, something like that. That's going to be the first thing that overrides. That's basically going to happen regardless of what's in your will. So if your will says property is going to cousin Susie and you own it with your husband as tenants by the entirety, or joint tenants with right of survivorship, it's going to go to the husband, even though he supposedly was in agreement with you going to Susie because she's your favorite niece or something of that nature. Now, one of the things that's happened, which is pretty, we don't have many things that's exciting in estate planning. I mean, it's quite, Bob was right. I mean, things happened in 1300s and we're still, talking about them. But we have, in the last few years, states have started using pay on death, transfer on death type of deeds, both for personal and real property. The real expansion has occurred on the real property. So it is now possible in DC and Virginia to prepare a deed that basically says my property upon my death, unless it's already joint tenancy, in which case it'll obviously go that way. But if it's a situation where you own the property outright at that time because spouse has died or some other family member has died, you basically can record a deed now that is only effective upon your death, but that'll transfer the property upon death. And what it does, it takes that property out of probate. So there is a value to that because most people would prefer to avoid probate if they could. Now, the deed itself needs to be recorded before the death of the individual. It also can be revoked, but there are written requirements to revoke it. So it is a tool. It's not going to be a tool for everybody. But if you've got the property, you're not sure what's going to happen. If you put the transfer on death deed in effect, if you sell it, you don't have to worry about it because the title company will probably want you to do a revocation of the transfer on deed. But even if you decide to sell the property later, it's not an irrevocable deed. It's one that you can cancel and transfer. So in certain states, that's a major issue. In the jurisdictions in this area, DC, Maryland, Virginia, probate is not a major factor. And the reason I say that, it still can be a pain in the rear end because you got to balance out those pennies on the accountings and things like that. But it is not an income producer for the states in the District of Columbia. There are states that have probate taxes that go up to 7 and 8%. Now, this is not an inheritance tax. This is just the fee for handling probate. Virginia, for example, runs maybe 0.2%, 0.3%. It varies based on the side, but it's basically designed just to cover the cost of running the office that's overseeing the executor. So unlike states, and you do, somebody mentioned earlier about Susie Orman and the need for trust, that is particularly relevant in a number of states, but the three states, the three jurisdictions in this area are not ones that is as of a concern. There are reasons to do trust, we'll try to get to that.
Excuse me, is retitling to make it to obtain a transfer on death title, is that expensive or difficult?
No, there is no tax on it. It is a transfer as, at least currently, see, Maryland doesn't have it, so I don't know what Maryland will do. They're discussing it now. But for example, in Virginia, there's no recording tax on something like that other than the normal transfer fees that the clerk charges. So, and that would be true also if it was a death, so they just kind of mirrored that situation. So it's a good way. It's a good way. It's a situation we didn't have 4 or 5 years ago. Some states still have not adopted it. I would say a majority of the states have now adopted it in some form. I would anticipate in the next 10 years, most every state will adopt some form of that. Other examples of things that override the will or insurance. If you name written beneficiaries on an insurance plan, that overrides the will. So if you did your insurance policy with the federal government or someplace else, when you got out of college and it still names your parents, please look at it again and make those changes. Retirement accounts we talked about before, they again are contractual obligations. They're going to override the will. So if you have a thrift savings plan, for example, and you have a designated beneficiary for that, again, that will override the will. So we're getting into a situation that we have to look at the distribution of assets, because if most of your assets are in categories where they're going to override the will, then what you're doing in the will may be handling 20% of your estate, but 80% may be handled elsewhere. And it may skew your intent on what you plan to give to your children or grandchildren or nieces and nephews. Ruth?
I have a question on relationship of transfer of death with both like a thrift savings plan and with the general mutual fund. Assume the person is single with no dependents as opposed to married, spouse, blah, blah, blah. So a single, no dependents. Is there a downside to designating the estate of John Kenny, single man?
No, of course not.
Of course not, right? Or, the estate of Susie Jones versus Susie Jones putting down the name of her brother and sister.
As a general rule, there are two things to watch. One is it's generally better to name individual beneficiaries rather than putting it back into your estate, okay? Because if you put it back into your estate, you have an account that says the estate of, then you put it back in a probate situation. So if you know the individual or group of individuals that you want to pay on death designation to go on your bank account or something, it's probably better as a general rule to do that. But then that goes back to the thing we were just talking about, is you need to make sure your estate is in balance, because if 90% of your assets are in bank accounts and stock brokerage accounts, and you transfer those to one person, and you have a will giving it to 3 people, you could have a situation where you meant to treat all the children equally, but for whatever reason you didn't. So that could be it.
And the taxes?
I'll get to taxes, but it shouldn't be, for most people, it shouldn't be an issue on that at all. It won't make any difference whether it's a transfer on death deed or a will or a trust. I mean, they'll all basically have the same, except for 2 of the 3 will not be under probate. One will, the will, but in terms of the federal income and state tax and stuff, it won't make a difference in the form that they're in. Yes, sir.
Have you ever had a situation where you had a deed transfer of a property that had a mortgage and the bank refused to allow the person receiving the property to assume the mortgage?
The Fannie Mae, Freddie Mac guidelines would allow a bank to do that if you were to give a property to somebody else in this room during your lifetime, because that is a transfer that they could call the mortgage. But death is a specific exception, and the way the transfer on death deeds are designed to work is they become effective immediately upon your death. So it is considered to be a death transfer, and therefore the mortgage is not subject to call based on that. Now, the person still got to pay the mortgage. I mean, if they don't pay it or something like that, then they're going to foreclose. But this type of transfer is not a transfer of during your lifetime. It's a transfer at your death. Although the deed has to be recorded while you're, it's a contingent deed, maybe that's the best way to say it. It's a contingent deed. Why don't we go to wills? As we talked about, power of attorneys are only effective while you're living. Wills take effect upon death. You can go through, use a will for specific requests, handle funeral arrangements, burial arrangements, things like that. Probably the most important thing that the will does is appoints an executor, somebody to handle the estate. If you have young children, it can also appoint guardians of those young children. The executor's role is a somewhat limited role. It only handles those, he or she is only going to handle those assets that are in your individual name. So if things are joint, that's not going to be part of your probate estate. And the executor is only handling your probate estate. That role usually lasts somewhere between a year and 2 years. The persons that are best to serve that role as executors are generally people like school teachers, business people, lawyers, accountants, government workers, people that are used to meeting deadlines, okay? Classic musicians are usually okay, but I will tell you that musicians and artists are not our favorite choice for executors. They're creative individuals, and they just don't understand when that notice comes from the court to show up because you failed to file that accounting. So there are personality types, I don't know on the Myers-Briggs scale what it is particularly big, but there are personality types that are better suited for that job than others. And it's basically people that make deadlines on a day-to-day basis. Yes, sir.
Are you excluding relatives?
No, no.
No reason to avoid.
No, actually, I like relatives over banks and other institutions as a general rule, particularly if somebody has a skill set that works. I mean, somebody has the ability to handle financial information, to do accounting work or something like that, or they know enough to hire an accountant or somebody who can do it for them. But no, I like relatives because I think they're generally going to follow the wishes. They know you better than some other organizations, and you can usually work out an agreement where they charge less. So I mean, it's kind of a potentially good situation. But a lot of people don't have relatives that fit that, or they're overseas maybe, or some other place. So they're always, each situation is different. Yes, sir.
Is there an ethical or legal problem to have the lawyer who wrote your will be the executor?
What we do in that situation is we require people to give to sign a letter. It's about a 4-page letter. I think different law firms do it differently, but we basically say, these are your choices. This is what we're going to charge. You have other options, and these are your other options. So, yes, we will do it. I think most law firms will do it. Be hesitant about a lawyer who writes his or her name in the will without discussing it, though. I mean, that would be my best advice. And I hate to say it, but there are too many examples of people, and regardless of whatever position they're in, whether they're a lawyer or a relative of of taking advantage of the situation. That's why the courts and the oversight is there to try to keep that, from happening, and that's why it's generally a good idea to have some oversight. Doesn't mean you have to have full accounting. You can have what they call unsupervised probate, or you can have in different states. The one that I like, particularly in Virginia, if a husband and wife dies and everything goes to the other, or also if there are 3 children and everything is going to the 3 children, if we name them all executors, we basically don't do an accounting. The theory being, and I think it's a great one, you can't steal from yourself. So if the beneficiaries are the same as the executors, there's a self-correcting situation, and the court really doesn't need to be involved. But in the 3 jurisdictions in this area, it's really not a court procedure. It's maybe overseen by the court, but it's usually an office or a private attorneys appointed by the court that are overseeing that, and they have a fee schedule for doing that. And it's usually at a cost type of basis. So it's not a bad system around here. I will say in New York, they still have the Widows and Orphans Court, and everything that gets done up there requires a court hearing, and it just runs up the fees astronomically. I've been practicing a number of years. I think I've had to go to court on probate matters a few times. I think I could do it on one hand, but I may have to go to the second hand, but I don't use all the fingers on the second hand, and that's probably over 40 years. So it's rare in Virginia when you have to go to court. It's rare in other jurisdictions around here. Not to say you might not happen. Obviously, if it's a dispute or something like that, you will. But as for general rules, there's oversight, and there's a question, they call and talk to you and say, oh, I don't think you did it quite right, we want you to refile it with this or something. It's more of an administrative procedure. June.
I was recently at a similar seminar, and it was mentioned, and I wanted you to comment on this, that if you live in Virginia and you designate as your executor someone who lives in another state, even if it's Maryland and it's a relative, that it may require them to post some kind of a bond. Could you explain that?
Sure.
Thank you.
It's easy. Remember, we were 13 separate colonies, okay? We formed a union, but a lot of our laws were based on being where the state was supreme until 1864 or 5, when that was probably decided finally. The state laws were supreme to the federal in many areas. So we had these different rules, and each state had its requirements in terms of who they had control over. They only had control over their citizens. So while you and I would look at it, and if we were in Virginia, and we'd say, well, isn't that hard to get from Arlington to Montgomery or Prince George's County or something? Historically, they would have these rules that would require something that we haven't in most states taken those off. We're starting to. But right now, if you named an individual, if you were a Virginia resident, for example, and you named an individual in another jurisdiction, they would have to have what's called a corporate surety bond. That is an insurance company that is insuring their performance of that duty. If they were a Virginia resident, they would not. Okay. Everybody who's an executor has to be issued a bond. They have to swear under oath that they'll do the duties, and there's a penalty, but it's not a corporate surety bond that you pay the insurance company a premium every year. It's your personal bond. But the court has that personal bond, and they will go after you if you don't perform the duties. That's what happens when you get the artist in and says, I don't understand what this thing is, that I have to show up and make a toothbrush in court next Friday. It's not, something that you look forward to. Now, the way around that, if you were particularly concerned and you had an individual and you didn't want to have corporate surety, is the next slide, which are the types of trust. Because you can establish a trust can name a trustee who's an out-of-state resident in every state. You can name well, I shouldn't say that. Every state but Louisiana, because I don't have any idea what Louisiana laws. And in that particular case, the trustee would be bonded, who would be bonded based on what language you have in the trust. If you say the trustee should be bonded, then they'll be bonded. If you say they shouldn't be, they won't be. So it's your decision on that in terms of the court maturity. But that's a way around that situation. If you have a particular person you want to name, but you're very worried about the insurance premiums that will occur annually on something like that. They're not terrible, but there's certainly something to avoid if you could in that sense. So you've got different types of trusts. The first one that we talk about is the testamentary trust. That's where the trust is basically established as part of the will. We often do that where you have young children, but you have a couple, say in their late 30s or 40s or something like that. Not a high likelihood that you're going to need a trust, because once the kids become 18, you won't need the trust, or 21 or whatever age you agree to. But you need a contingent trust because minors under 18 cannot have the money themselves. They need somebody as an adult to supervise that. So the testamentary trust however do not avoid probate, so they're part of the probate process. And in most jurisdictions, there is an annual counting requirement on the trust. So more and more people are going to inter vivus trust and just trust among the living. This is when people talk about trust, or when Susie Orman talks about them, this is the type of trust that they're, effectively talking about. You're just establishing, in most cases, a revocable document that you can change, destroy, modify, do anything you want during your lifetime. And at that particular time, you basically set down what you want, knowing full well that as long as you're competent, you can change that in 5 years, 10 years, or 2 months. So it basically will do the same thing as the will. Only difference is that it's much better for a longer term relationship, particularly if you had somebody who was a special needs individual that you're trying to take care of. That's probably not a good thing to have in a will and a testamentary trust. Inter vivus trust would be particularly better. It would be more flexible potentially. We have a number of irrevocable trusts. Most of those are tax related. Like the insurance trust is literally a way so that the insurance proceeds that you might receive are coming outside of the probate or the taxable estate. So what you do is you basically set up a trust to hold the insurance policy. You give your beneficiaries, who most of the time are the same beneficiaries under the insurance policy, money every year to pay the premium on that insurance policy. So the insurance policy is not owned by you, so it isn't part of your estate. It's owned by the trust itself. So there are, reasons for doing that. As I get into the taxes, some of the reasons for the different types of irrevocable trust are lessened because of the Congress action at the end of 2012 in changing the amount of the exemption and putting in a doctrine called portability, which we'll get to. But the type of trust you can set up, most of the ones that are tax planning trusts are irrevocable. So you pretty much need to be sure that you're not going to need that money, or there's not going to be any other, you're not going to change your mind 5 years from now. Because once you set those up and start funding it, those are irrevocable. You can do the kiddie trust, the grandchildren's trust, things like that. These days you can do a lot of that with a 529 plan or something like that. So these, again, are alternatives to other plans. Obviously the 529 is limited in how much you can put into it. The grandchildren's trust would not, so there's still reasons for doing that. We go to the federal taxes. First of all, any transfer between U.S. spouses to a U.S. citizen are tax-free. If, yes, sir,
I have a question about the trust.
yes.
Is this something that you can do on your own? I talked to a lawyer and they said that they would do one for me and I could just copy it for another property? Or is that something that you need a lawyer to do the whole?
The trust, I'm not sure which trust you're talking about because there are such things as called land trust, and they are property by property. And certainly if you had one, most likely the same format. But the trust, most people in this room, the trust that they'd be setting up is a revocable trust, and it's designed to handle all their assets. It's designed usually to potentially avoid probate. It may be designed to make sure that your wishes are carried out over a longer period of time. And you'd only need one of those trusts, so I'm not quite sure what that.
So if you had a few properties, you'd have one trust and then you put the properties in that trust, is that right?
We'd have to fund the trust.
Yeah, I mean, the deed, the owner of the properties would be the trust in that situation. A lot of people, just FYI, would recommend that you put the properties in a limited liability company.
Yeah.
Okay, well, so you've got some good advice. Put the limit, and then have the limited liability company owned by the trust. So if the only thing you do if you went out and bought another property, you need to make sure that you put that in one of your existing limited liability companies or set up another one to own it, and then that one again would be owned by the trust. Okay, that's both a liability protection situation and an estate plan mechanism.
Okay, then you have to re-report it when you put the LLC into the trust?
No, you don't have to record the beneficiary change in the ownership of the LLC, but each time you have a deed and you buy or sell a property, there's going to be a deed transfer, obviously, in that case. So if the property is owned by Arizona Associates or something like that, and you want to change the beneficiary from yourself to your trust, that would not require a deed. That would just be a document change in the trust agreement. But if you were transferring your property from Arizona LLC to California LLC, you would need a deed transferring it from one to the other. There was another question, but maybe. So let's talk about taxes. Probably the best way to say this is Congress has made this easy and the President signed it for most of us. The current exemption amount is $5.34 million for an individual, and a couple with portability, which I'll get to, of $10.68 million. This is probably fairly permanent, as much as anything is permanent in this city, but it is likely to stay for a while. I'm one of the few people that stayed up and watched Congress on that vote in December 2012, and I will tell you that the portability provision, which we'll talk about, passed by the greatest majority. The exemption amount, which is really not an exemption amount, but that's what people call it. The exemption amount passed by a fairly hefty majority. The one that was really close, and the closest, was the reduction of the estate tax from 45 to 40%. So my own assessment is if they make changes and they're raising funds, they're going to raise the amount before they touch the other two, just given the vote before, because, and I'll talk a little bit about portability. But before I talk about portability, let me go back and talk about qualified domestic trust, because I know a number of people in the foreign service spouses are not U.S. citizens. So you don't have to establish a qualified domestic trust during your lifetime, but you're going to have to establish one if you're giving money to a non-U.S. citizen spouse. But that can be done as part of your will. You can instruct your executor to work to establish a qualified domestic trust, and that means the spouse, as long as he or she lives in the United States is going to be able to spend that money and use it. If it's over a certain amount, you have to have a U.S. financial institution managing it. If it's below a certain amount, I think it's around $2 million, an individual can manage it. So let's go to portability. Sorry, yes.
If you have a non-American citizen spouse and you jointly own a home and you die, you're saying that you should set up a qualified domestic trust first? How does that change?
No.
What happens to the spouse, the non-citizen spouse, if they end up owning property here and they're not American citizens? Because they've inherited it
Well,
from an American citizen spouse.
if they've inherited it and there's no other exemption that applies, they're going to pay a 40% tax rate. Okay? So the qualified domestic trust works, the exemption amount works. There are a couple of exceptions to it, so it's not going to happen in many cases, but it used to be, and this is the reason I brought it up, it used to be you had to establish that trust before death. Okay? That was changed 10 years ago or something, 15, I'm not sure exactly, but it's changed fairly recently, so that all you have to do is, if you need it, you put a reference in your will that says the executor is authorized and directed if necessary to set that trust up. Because otherwise you are going, if you fall in, if you don't fall in under one of the exemptions, you're going to find a very nice tax bill 9 months after that.
And does that applies to everything in the estate? Let's say you've already sold your house and your estate is, I don't know, stocks, cash, et cetera. No real estate property, but it still applies. They would still pay 40% unless you have that.
So the government's, the intention is so that the spouse does not move overseas, a little bit like the inversion issue, but the spouse doesn't move overseas and they never get the tax from the situation, okay, from the death, okay? But that's much less a concern than it used to be because you can establish a qualified domestic trust or people are going to have an exemption amount that covers it anyway. In the back, yes.
Are you going to cover state taxes on the states?
Lauren is actually. We are. Yes, sir.
So does the exemption amount apply to a non-U.S. citizen spouse?
It's my understanding.
That was my next question. So if the exemption is that big and your property is less than that, you're not going to pay the 40% tax?
That's my understanding. As a general rule, you can give that money to anybody and it's really going to be covered by. Now, here's where the problem comes in. A lot of countries have inheritance taxes. So a number of countries, even though you might not wind up with a U.S. tax, because we have generally estate taxes, we have a few states that have inheritance taxes. An inheritance tax is a tax that's imposed on the individual receiving that gift. So, for example, if you're in Germany, Hungary, Sweden, or you're a citizen of those countries, you may have an inheritance tax regardless of whether you have a U.S., whether the state has a U.S. tax or not. And believe me, there's a whole industry in Europe of lawyers and accountants that have been set up to get around that. So whatever happens is I just listen to the accountant or the lawyer overseas and basically they say, we want you to do it this way. And I almost get the request for a letter saying this is not an avoidance of taxes. It's I don't know what that's worth, but at least it makes them think twice. And there are, just like there are in the U.S., there are ways usually to get, somebody very creatively can probably find a way around the inheritance tax or reduce it significantly because of different exemptions, or they can disclaim and then they give it to their children and them, and each one of them gets an exemption amount. So the $100,000 that they only had a $25,000 exemption amount, all of a sudden they disclaim, so that now they're giving to the 3 children and themselves, and they each have a $25,000 exemption, so all of a sudden there's no tax on the inheritance. So there are things like that that are done in each of those countries, it seems like. Doesn't say that we haven't paid inheritance tax over, which we certainly have. But there are a lot of exemptions, and people seem to know how to deal with the exemptions. The portability is a doctrine that went in, as I said, at the end of 2012. I think portability is here to stay. What does that mean? It basically means if one spouse were to pass away and they left their money to the other spouse, under certain circumstances, you can then double the 5.34 million exemption to 10.68. And that covers 97% of the population, even with the cost of housing in the DC area. So you basically, but there are things you have to do. You have to file a tax return. You have to file a federal inheritance tax return in order to be able to use portability. So that's one of the provisions. But it eliminates a lot of the needs where we had bypass trust and AB trust. And we did the same things without legislation up until 2 years ago, 2.5 years ago. We basically established a trust for a marital trust and a family trust. We put certain money in one and the other, and that's achieved the same purpose as portability. Portability passed, as I said, with an overwhelming vote. It had members of the Black Caucus and at the same time the most conservative Republicans in the Congress voting for it. And people voted for different reasons, some because they didn't believe in taxes to begin with, and others, particularly on the Black Caucus side, who basically said, we've got a lot of individuals in our constituency who maybe have, maybe have done well, have had an auto business or a food business or something, and they made it themselves, but they didn't learn they weren't a Rockefeller or Gates or somebody who had accountants and family members from birth, saying you need to do this, you need to do this, and they got hit with large state taxes. So it was one of those provisions that kind of had across the board viability on the theory that if one spouse dies and gives everything to the other spouse, they should basically be able to take advantage of both of them, which they were able to do before, but only with a bypass or an AB trust. So it eliminated the need for that particular part of the trust situation. The same thing is generally going to apply between same-sex couples, because if the state recognizes the marriage, they're going to recognize this in terms of and the government has pretty much acquiesced on this, they're going to recognize the same thing on the portability situation. Now, Congress hasn't acted on that particular issue, but the Treasury has issued regulations on this. All right, so you do have to elect portability. That's the one thing to remember. I'm going to turn this over now to Lauren Keenan, and she's going to talk about inheritance taxes and some of the other things specific to foreign service.
One quick question on portability.
Yeah.
If you, upon your death, take some part of your estate and give to surviving siblings or what have you, deducting that part from, how does that play from your
The spouse has the remainder. Hypothetically, if you were fortunate enough to have 5.34 million, okay, it would be all exempted, but let's say 2 million went to these other parties, like children or nieces and nephews, and 3.34 million went to the spouse. The spouse would then have that 3.34 million add on to the 5.34 million. The 2 million has already been used, so you don't get to double count that. You basically get what you received, and you can basically do that. But even if, hypothetically, you could have a situation between spouses where there's a disproportionate amount that's owned by one spouse versus the other because of an inheritance or something like that. So you could have a situation where one spouse passed away without that large of an estate, but they had the ability to pass over. That can be transferred to the other spouse, the spouse with the more assets, even though the spouse who the first to die did not have all the assets. That's an exemption amount, and if they filed a tax return, then they'd be able to transfer it.
Does that apply to non-citizens, to property owned overseas? Let's say my non-citizen spouse dies before I do, and we own property overseas, and I choose to sell that property and, repatriate cash. Do I have to elect portability or something, or am I subject to some kind of tax or on that?
Run that one by me again. I think you've got it.
Okay. So I don't
You've
know-
got property,
Yeah.
husband and wife own property overseas.
Right.
Okay.
Husband is not American citizen. Husband passes on before I do. I decide I'm not gonna live in that country anymore, and I want to sell the property.
That's not a problem because you're a US citizen.
Okay, so I sell it, and then I can repatriate the money, and I just take whatever foreign exchange losses or whatever,
Or whatever that country's
and then I
tax laws
declare
may
that,
be.
but is that income? I mean, or I own it, so it's presumably.
It would not be US income because, let's take the hypothetical, the property's worth $200,000.
Right.
Okay? And that was the value at the date of the husband's death.
Right.
Okay? And at that point in time, if you sold it for $200,000, the US would not consider that a taxable event.
Right.
It may be that you are paying some tax overseas
There.
because that's going to vary from country to country. But for the US part of it, you would not be paying tax. If it went up in value from 200 to 400, let's say you waited 10 years to sell, then yes, you would be subject to a tax on that, plus whatever tax you may be subject to in France or certain,
Okay,
any other
Okay.
country.
thank you.
Yeah. You want me to-
Hi, everyone. As John said, my name is Lauren, and I wanted to cover some of the state estate taxes. John talked a lot about the federal estate tax situation, but as you'll note from this map that we took from Kiplinger.com, the red states shown here are states that actually have their own estate tax or possibly their own inheritance tax. You'll note the red states, there's quite a few, there's roughly 19. Several of the states shown on this map are in the process of aligning their state estate tax with the federal exemption, so phasing out estate tax. Among those are Maryland, Iowa, Connecticut, and Tennessee. All those states are kind of looking at their state estate tax to see if it's something that they do want to phase out and have aligned with the federal estate tax. So, but you will notice on the map here, DC and Maryland are red. Virginia is orange, and Virginia tends to be not only fairly friendly from a probate perspective, as John mentioned, but also from an estate tax perspective, in that it does not have state estate tax. It does not have a state inheritance tax.
You would then tell me.
It's a little arrow. But right. Yes.
Yeah, as far as Washington DC is concerned,
Yes.
does it have an inheritance tax for any bequests that are made to people other than children? I know in Maryland, does have both an estate tax and an inheritance tax if the
Mhm.
bequests are to other than children. Does Washington DC have the same practice?
Right, so no, DC does not have that practice, but as you stated really well, Maryland does.
Okay.
So here actually is sort of a summary of the state estate taxes. So we have, about 19 states in the District of Columbia that have either or maybe both in some cases. And we just have a rundown here of Virginia, Maryland, and DC being the most relevant people in this area generally. Maryland has a $1 million exemption for state estate taxes, so there is a tax on assets above that level, same as in DC, and the tax rates are roughly the same. As I said, Maryland is in the process of looking at phasing out theirs. In DC, there is some talk that they might be doing that too, but I think Maryland's a little ahead of DC as far as taking some more concrete action towards that. Yes. Oh, sorry, Jane, I'll come to you in a second. Yes.
So if you own a house in the district
Mhm.
and a house in Virginia,
Mhm.
you would have, you would pay state taxes on the, unless it met the exemption, unless you were under the exemption, you would pay state taxes for that one bit of your estate in the district and not in Virginia, but you'd have to be working in both court systems?
Correct. And that's called ancillary probate, and that means you have more than one probate going on at the same time.
Or Florida and DC or Florida.
It's really
and-
common, yeah, Florida would be a common state that a lot of people might have real estate in. And trusts, revocable living trusts are used a lot of times as a vehicle to try to avoid that situation, frankly. For people that own property in multiple states, trusts really can be very useful and helpful to avoid going through probate in a very, particularly if you own property in an unfriendly probate state like California or someplace like that, like John and I were talking about, John was talking about rather earlier. But I did want to say, just for people in DC or Maryland, that the worst state for state estate taxes is allegedly New Jersey, which has $675,000 exemption. So I thought you shouldn't feel like you're at the very bottom of the list. There is a state out there that's even more unfriendly. So, June?
Wanting to be sure I absorb the first part of John's presentation. If I have a first savings plan with a transfer on death, and if I have other mutual funds and they all have transfer on death, those become not part of my estate, is that correct?
Yes.
So that when you're talking about estate, you are talking about only those things for which there was not a preceding transfer. So, am I following this? So if you and your spouse are jointly listed as joint owners in real estate,
Right.
then that shifts to the survivor, and that's not part of the estate, right?
Well, the spouse is exempted in all three states.
I guess
So,
what I'm
yeah,
trying to
it's still per-
understand, and I'm sorry if I'm being thick, is what is in the estate basket and what can be previously pulled out of
The
the
tax
estate
tax
basket.
basket is larger than the state tax basket. So you would, in Maryland or the District of Columbia, they would be looking at all the property you own in Maryland, whether it's in a trust, in the state, or a transfer on death. So
Okay.
that is a bigger basket than the estate basket.
Okay.
But they still call, you're absolutely right, they call them the estate tax. It's probably, it could just be called a transfer of death tax or
It's
something like that.
essentially an asset at death.
Yes. that's-
So if I
that's
have
good.
$500,000 in my first savings plan, and I have a property in DC or Maryland that's worth $750,000 for a total of $1.2 million. Regardless of what I've designated, that's my taxable estate in Maryland or Virginia, Maryland or DC. Am I following
Yeah,
you
the
now?
only thing that would be different, if, for example, you lived in Virginia, the situs of your personal property, in other words, where the personal property is going to be taxed, is the state that you're living in. So even though the bank may be a Maryland bank or something like that, they're going to consider the bank account to be owned by you in Virginia. And under the example you gave before, with $750 in real estate and $500 in bank accounts, you would not have a tax in Maryland or DC, because they only have $750,000. They don't have 1.25. So it becomes important of where your personal property is located, and that is going to be considered where you are. The real estate is always going to be located where it's physically located. You can't change that.
So not to belabor this, but so I think it's something that kind of generally applies to yourself. If I live in Maryland and I have a house worth $750,000, and I have a thrift savings plan worth $500. Would that mean that in Maryland, my estate for state tax purposes is 1.25 million? Is that right? That's the number.
Yes, sir.
You mentioned that California inheritance tax is difficult. What do you know about it?
Oh, I'm sorry, I didn't mean to imply inheritance tax, the probate process.
Okay.
Yeah, and it's just from, I don't have experience dealing with it, but from what I've heard, it is a very lengthy process, and as John said, the tax rate on what is probated is higher than it is in here in Virginia, it's a very nominal rate. So there's a larger fee and cost associated with it, so there's more incentive for people to do planning with trusts and revocable living trusts and transfer assets to those during life so that they don't have to go through that process. Or put, family members through the probate process of administering the trust, which can apparently be kind of onerous for them. Yes, in the back?
Are we correct in assuming that estate is only levied on the estate left by the deceased and inheritance is only at the receiving end?
Yes, you got it,
So-
exactly.
So in other words, one might not have an estate tax, but if one had beneficiaries in different states, they may each have a different situation.
That's right.
Depending on the,
Yeah, and also leaving money to family members or friends or people that you know overseas, and the implications of that can be different for them receiving that income or receiving that gift. So, inheritance taxes, as we pretty much covered, it's very few states have them, but there's approximately 6 states that still do, one of which being Maryland, the closest to us here, with 10% tax for anything to non-lineal heirs. So as we were talking about outside of children, you're giving gifts to others, they do have rather, as the recipient of the gift, a tax that would be applied.
how would one find out what those states are?
Well, I think, not to put a plug in for Kiplinger.com, but they have a great website that covers, maps of all different, estate taxes, what states have what. You can do a state-by-state profile. So, I don't have a list of the 6 states, and of course you could email us and we could let you know, but, I don't know them offhand. But if you go on that website, you can actually do a profile. So let's say you do have an interest or you may have plans to retire in a certain state, have family members in a certain state. I know for myself, my parents have thought about relocating this area, and I often have concerns from a state planning standpoint of living in like Maryland, as opposed to living in Virginia. So you can look online and see a lot of profiles of what the tax structure is in different areas. I think it's pretty helpful. Okay, and federal gift taxes, which is different than to some extent different than what we've been talking about with the federal estate tax or the state estate tax. With gift taxes, currently the exemption, the lifetime exemption and the federal estate tax exemption are coupled, if you will. They're the same, they're aligned. So it's easy to remember the numbers right now. They haven't always been that way. But currently, the federal gift tax and lifetime exemption of what you can gift to others is $5.34 million per person. So again, you have that ability to make gifts during your lifetime or at death in that amount without having a tax consequence. That said, the annual gift exemption is the amount that you can gift to any individual, and it can be any number of individuals. So you can make $114,000 gifts to individuals without paying a tax on that gift. If you make a gift for $14,001 to somebody, then technically that $1 is starting to go towards your total $5.34 million exemption. So gifts over that annual amount, and the $14,000 each year is indexed for inflation and changes, so it's $13,000 and now it's $14,000. If you combine gifting with a spouse, you get double, so you could do a $28,000 gift. But anything over that amount, you start applying gifts to the $5.34 million, and you start reducing that amount that you can then transfer at death. you, as John mentioned, you can do, any transfer to your spouse is not a taxable gift. However, non-US citizen spouses, their transfers are only tax-free up to a certain amount. And currently that's $145,000 in 2014. And again, that adjusts each year for inflation. So there is a different standard for non-US citizen spouses. Yes, ma'am?
Just to be sure I understand,
Yeah.
the excess, if it's over 14,000, is paid by the person who gives the gift, or the person who receives it, or both?
By the person who gives the gift. So similar to your estate tax, how you are giving of your assets at death and your estate is being taxed. If you are giving over that amount, you are paying a tax. Or you're probably not going to owe a tax because the lifetime exemption is so high. So if you're not exceeding 5.34 million, you're not going to owe a tax at that time, but you are required to file a gift tax return and note the amount of the gift that exceeds the $14,000 gift.
Okay, so it's not the year you give it, it's.
It starts adding, excuse me, it starts tallying towards your total exemption. Yes, sir.
I would just add to the question that, basically, at the time, after you die, the amount of total gift tax returns that you filed in your life is counted towards the value of your estate, and that has to be declared on the federal and state tax return.
Right. He's saying what you file during your lifetime as far as those annual gift tax returns that you file where you're earmarking the amount of gifts that exceed the minimum exclusion amount, that later you will need to again note those gifts that you made during your lifetime when you die, because they will count towards your total exclusion that you can take at that time, or your estate can take at that time. It's reducing that amount. Would that be? Yes, sir, in the back.
On the last point about the gift taxes, about to non-US citizens, what about receiving a gift from a non-US citizen, and then who would be responsible? Is there a limit there, and if so, who'd pay it?
I'm not aware of any limits or any implications. In fact, I just recently had a client who told me that I didn't know this, but that the UK, and again, according to a client of mine, that the UK doesn't have gift taxes, so they were receiving a gift from a family member that was rather sizable without any tax consequences to the giver or to them as recipients.
The US doesn't care if it's coming from outside, only if it's.
Unless that country obviously has its own,
Right.
yeah, which I'm not.
But in that case, the giver would be responsible. So.
Right.
It's not income.
Right.
If you got the gift, it wouldn't be income to you in America?
No. Just a gift. Yes, in the back?
Little hard to hear in the back,
Oh.
but were you saying that if you went over the $28,000 by $1, that $1, the person who, it would not be taxed, but it would be deducted from the amount that one could complete a person?
That, what's the last part you said?
It would be deducted from the amount you could bequeath the person?
It would be deducted from your total lifetime exclusion amount, the 5.34 million. The next slide here is talking about gifting strategies, and this is something that comes into play for a couple reasons. I mean, one is just people having an inclination to make gifts, wanting to gift to grandchildren or nieces and nephews, a lot of times for education, things of that nature. And then also when someone is in a situation where they will have a taxable estate, sometimes gifting and putting into a gifting plan can be helpful to transfer set amounts of assets during your lifetime and to reduce the overall size of the taxable estate. So sometimes gifting is a strategy that's planned out with an attorney's guidance to reduce the amount of taxes that will be due at death. Other times it's just simple as wanting to give a gift or provide, obviously, for someone else. So cash and appreciating property are often gifted something to think about when making a gift, as John touched on, is the basis of the gift. When you give someone a property at death, they get a stepped up basis, which means they get it at that current value, which can be very helpful for them when they in turn sell that asset down the road. They have a higher basis, and the taxes are calculated more favorably for them on that transaction. So gifting is often a strategic decision, as odd as that might seem, since most people that give gifts just do it out of generosity and wanting to do something nice for someone. But you can often have a strategy behind which assets you gift and how you go about gifting them. Uniform Gifts to Minors Act is important. Again, as John touched on, gifting people or children who are under the age of 18 is problematic. So you do need to take a look at who is going to be the adult in charge of those assets. Oftentimes we're talking about doing trusts for minor children that puts an adult in charge of the assets they're receiving for an extended period of time, often well beyond age 18, when they can inherit the assets. We're often extending the oversight of those assets until they're 25 or 30 is pretty common. So keeping in mind the age of the recipients of the gift is important. It's important to note medical expenses and tuitions that are paid directly to the institution are not a taxable gift. So you can gift more in those instances, so long as you're paying directly to those institutions. Again, that might come up with maybe a niece or a nephew or a grandchild or somebody like that, I'd imagine. Installment sales or loans were something that John's going to cover in just a moment, so I won't go into that, but it's another sort of in the gifting family, if you will. And charitable giving, of course, is something that a lot of people do, and a lot of people like to include in their estate plan. So that's another thing to always have in mind. The last thing I wanted to talk about is just spousal rights. Much like John said, titling is an issue that people may not really be aware of, and they think, well, whatever's in their will is what's in their will, and that's kind of the number one controlling document. But titling plays a huge role, and similarly, rules for surviving spouses play a big role in estate planning, and sometimes people I don't think are aware of them, and they don't realize that what's in your will may not control if some of these rules are violated or some of these rules come into play. So spousal rights, the bottom line with spousal rights is that you really can't disinherit a spouse unless they agree in writing to that effect. So, prenuptial, postnuptial, some sort of written agreement that you put into place will be effective generally, but otherwise, typically a spouse has a right to inherit from a deceased spouse. And in Virginia, we have the spousal elective share rights, which are at the bottom of the screen here, and the omitted spouse rights. Those are Virginia code based, so they control no matter what's in your will, unless, like I said, you've done some sort of agreement with your spouse. A spouse who isn't provided for adequately in a will has a right to claim an elective share within 6 months of their spouse passing away, and is entitled to a certain portion of their estate, really regardless of what the will says. Similarly, an omitted spouse is a spouse who marries someone after they've already prepared a will. So let's say you have an older will providing for your children from a prior marriage. You have that will in place, you think everything is hunky-dory, you get married again, you maybe have a discussion about the fact that you have the will, but you never update anything or provide for your new spouse. And the new spouse, when you die, if you've never executed a new will, is an omitted spouse and has a claim to the estate. And under the omitted spouse statute, it can be as much as the intestate statute in Virginia, which is 100%. There's no children from a prior marriage. So there's some major, I've had some conversations with family members where they aren't aware of these rights and they aren't aware of these claims, and they think that the father and the new wife had talked about all these things in advance. And unless it's in writing, it's actually, those claims exist, and there's something that the estate would have to often deal with. So getting advice in advance is a good idea. Yeah.
I've been looking at this issue of how much to, whether to give this my spouse the maximum or the minimum amount
Mhm.
of in the survivor benefit. This is an incredibly complicated issue that has to do with actuarial issues and everything, and I just can't figure out how to do the math. What advice do you have on how to I mean, I know you can't give advice on a particular situation, but how to go through all that and figure it out?
That's a great question. I don't know if John has more practical advice on that, because I can't say math is ever our strong suit
Yeah, I know
as
it's more of a financial
attorneys.
planning issue than
Yeah.
a legal issue.
But aside from that, I mean, I think it is a matter of first, knowing what the rule is, right? And you could, oftentimes in estate planning, there is a way to set a formula in place that you don't have to actually figure out the math today. You could do some sort of drafting that would allow you to have a plan that incorporates whatever the formula is. I mean, in this case, I think what you're talking about is foreign service default rules is what you're referring to, right? So, in this case, it's for, I'm sure you all read it already, but for a former spouse of a foreign service person or participant, they are entitled to 50% of the retirement annuity, or a pro rata share of the maximum survivor annuity. And then, as you said, it gets complicated because there are these conditions that must be met. So that the divorce must have happened after 1981. It must have been before they started payment on the annuity, and the former spouse could not have remarried before age 55. So if they remarried after they're 55, they're still in the running for this 50% of the annuity. And then, in addition, they must have been married to the former foreign service employee for at least 10 years, during which at least 5 of them, they were participating in the foreign service. So it is a rather complicated rule. I don't know offhand how you would best calculate the figure. I think probably getting assistance from someone in HR.
No, I'm talking about, this
Oh.
is maybe beyond what you're
Maybe
talking
I'm
about,
just
but
misunderstanding.
you can decide, for your current spouse, you can decide whether you get a higher pension or you get a lower pension,
I'm
and you
sorry.
give them, and they get more when they survive it, but,
Oh, I see what you're saying. Yeah, I think that's more of a financial planning question as to what sort of assets you think you anticipate you will need for retirement and so on, than it is really an estate planning. From the perspective of where those assets would go, it's something that you can help address. In the back?
What is the legal definition of spouse?
That's an excellent question. I imagine it might be state specific, and I don't know, why do you ask? I mean, do you have something in mind?
Well, because there's such a broad array of living arrangements among people today. The definition of spouse, which you use the term all the time, what is the legal meaning of it?
Right. Well, in Virginia, they certainly think they know, right? It's been a topic of a lot of debate lately. But I would say probably if we were to look at the Foreign Service manual, there is a definition that applies for this particular benefit, and then so on and so forth. But I don't know. I can't really recite that. It's a good question. Yes. You know the answer? Or yes.
Me?
Yeah.
I don't think I know the answer.
Oh.
Wouldn't the spouse be considered someone who's legally married to?
Yes.
Okay. And I presume now in this foreign service, I don't know about Virginia law, that if I'm not mistaken, same-sex couples who are legally married and wherever they marry are considered spouses. And by the federal government, I think that in effect, the benefits that would be given to a heterogeneous couple now also include same-sex couples.
Right. Yeah, and that's right, and that's been in the news a lot as of late, and it's correct from a federal benefit standpoint. There is no difference if you have a valid marriage license from any state that permits same-sex marriage, or any other state where you have a valid marriage license, you're going to be considered spouses and treated the same. You're right. But state law hasn't really caught up that. Yes, Jim?
I think the tougher issue is not the same sex, it's not the marriage by, decree. It's the common law marriage situation where in some jurisdictions, if you live together, hold yourself. In some jurisdictions, living together for a period of time is enough. Others, you have to hold yourself out as being married even though you aren't officially married. So that's why we tend to throw up our hands, because we just honestly don't know. There's probably at least 10 or 15 states that recognize common law marriage, and they're all different. DC does recognize it, Virginia does not. So, that's where it really gets minefieldy, and we'd just be guessing.
Alright, so, did you?
No,
John's just gonna finish up with a few more slides and a few more topics of interest, and thank you all very much for listening.
Excuse me, I did have one question on one of your slides.
Yes.
The gifting for educational expenses, does that also count retroactively where you can pay off student loans or something like this?
I don't believe that it does, because that's a responsibility of the individual. That's a really great question that I actually haven't looked at before. But as far as I know, that's an individual responsibility. The person took out the loan, and I don't think it's covered under that exemption. But I'll follow up and let you know unless John knows otherwise. Have you ever heard of that?
It just occurred to me, you've really opened up the possibilities, because
Yeah, I like it.
instead of taking out the loan, which the individual's taking out, what if the money was borrowed from the institution and then the payment was made by the grandparents to the institution? I think that it would qualify in that situation, but there's maybe private letter rulings or something we'd have to look at. But as a general rule, when it's a loan, it's an individual obligation, it's not to the educational institution. Let me just talk about, and we'll finish up very quickly, about interfamily loans. Right now, that is a very good thing to consider. If you're thinking of giving a gift, for example, to a child or grandchildren or something like that, the potential of making a loan to them, either by allowing them to buy a house that you own or some property like that, or just making a loan to them rather than a gift, it does potentially provide you with a certain amount of income. And right now, what you have to do is if you make a loan to a family member, you have to follow the applicable federal rate, which are set up for August. It changes the September will be out next month. So if you were doing, let's say the midterm loan is 3 to 9 years, that'd be 1.86%. 1.86%. The long term, just under 3%. I think it'll be up over 3 next month. But if you were giving the kids money, they would pay you at 3%, which is lower than they can borrow from the bank. So if they were using it to buy a house or set up a business or get married or any number of things, it might be a good way with the rates so low now for you to consider, because instead of just giving up the money, you're continuing to get, in effect, an annuity. I mean, you're going to continue to get that money over the period of time, and it might be better for some people to consider that, because rather than a gift, some people may prefer that the children take more, or grandchildren take more responsibility to pay the money back. And if you felt that they were struggling or they're in a situation, you could always forgive the $14,000 or $28,000 a year on the mortgage payment that would, or the interest payment would do, plus some of the principal. So it's just a mechanism to consider, and it's basically good to consider now when rates are so low. Yes,
If you wanted to make a good deal for the kids, why wouldn't you just give them a 3-year loan and then flip it every 3 years?
Well, if you knew for sure that the 3-year rate would be that 3 or 4 years from now, but what if it went up to 6% at that time? Then you'd be covered, you'd be starting to pay 6% on a 3-year loan. For those of us who lived through 1982.
18%.
Yeah, I mean, people would come to the office and say, I just got a 14% mortgage. I mean, it's like, absolutely ecstatic at that. So again, good strategy, but it might not work. I'd be inclined to go with the 9-year rate if you were thinking that, at least tie it down for, a period of time.
So, but this all has to be formalized, or
Yes,
or to what extent does it have to be
absolutely.
formalized?
Absolutely has to be a written document. Yeah.
Which a
But
lawyer
that's
have to
just,
prepare?
that can be a promissory note. It doesn't have to be anything more than that. If you want it secured, then you do a mortgage or a deed of trust. But it should be fairly simple, should be fairly straightforward. That's, yeah. Let me just touch on a few things. There are trends that you see, and for most people here, it's not going to be that important, but what is happening is the small states in the United States are moving towards adopting a self-settled asset protection trust and or a dynasty trust. I'm taking the first and the fourth one together. And what that means is that those trusts, the self-settled trusts, are protected from your creditors after a period of time. In Nevada, I think it's now 2 years, it used to be 3. In Virginia, it's 5 years. What is generally happening is it's happening primarily in the smaller states, Rhode Island, Delaware, South Dakota, North Dakota, Nevada, Alaska. The states that have smaller populations, Wyoming being a major one. And why are they doing it? Because they're not going to get that much in inheritance taxes or estate taxes. But if they require that you have a Wyoming financial institution, you have a Wyoming accountant and a Wyoming lawyer, you're going to make more off the income taxes of those individuals than they ever would off of your state taxes or something like that. Now, the self-settled asset protection trusts are a little bit different. They're not like the dynasty trust. They are a way to literally put the assets that are in that trust out of the reach of creditors. Now, will they hold up totally under challenge? I don't know. I think in the states that have them, they probably will because they're not against public policy. And if you had one and lived in another state and you set up a trust, you may have an issue because it may be considered against state policy, against public policy in the state you live in. But what these are doing, and they're becoming, it's all occurred in the last 10 years, but they're becoming very popular, like for doctors and individuals like that could be subject to high malpractice claims or something like that. They still have assets outside of what's in the trust, but they're putting large portions of funds in the trust, and after a number of years, if they didn't have ongoing claims, or they didn't have a claim now, then that money would be protected. It's kind of like the same thing that your retirement benefits are now under federal and state law. Those are generally protected from the rights of creditors, so you'd be adding a number of protections. The ones listed, medical profession and building contractors, both because of site injuries or malpractice. The trust decanting statutes, that's a very interesting thing that's occurred. A lot of people might have grandparents or aunts and uncles that set up an irrevocable trust, and everybody has always said you can't change those. Well, it may be possible now to change some of these old trusts under decanting. Decanting is not a wine, connoisseur term in this sense. It is literally, but the concept is the same. You're pouring, just like you're pouring the old wine into a new container. You're taking the old trust, keeping the beneficiaries the same in most cases, but changing some of the terms, like when payments can be made, the type of payments, the type of investment that can be done. It needs to be done with consent usually, but it can be non-judicial. We've always had the ability to change the trust with judicial, but if you had 3 beneficiaries and they agreed that when grandma set it up and they wanted the kids to get the money at 70, that wasn't realistic, and they're all 45 and they'd like to get the money, with the trustee's permission, they could change that right now and probably go forward. The other thing that's happening is a number of trusts were set up in the jurisdictions the person lived in, like New York or Pennsylvania or Virginia. You now have the ability, we've always had the ability, but it's become much more flexible, the ability to change the situs of the trust, to move the trust to another jurisdiction that has much more liberal, or liberal would probably be the, you know, permissive, maybe the better word, trust laws. And there may be a reason to make those changes. So if any of you have family members that have that, and they were told 10, 15 years ago there's nothing they could do, they might want to look at that. And then we'll close on when to review an estate plan. Those are basically major life events. Tax law changes like what happened in 2012, they periodically happen, could be every 5 years, every 10 years. Significant changes in value of assets, obviously. If you win the lottery, that's going to make a difference. If your aunt dies and leaves you $5 million, that's obviously going to be major changes. We say every 5 years. I think it's every 5 years is just a guide. It's kind of like the shampoo where it says rinse, lather, rinse. I thought that was the best advertising thing ever. You didn't do that rinse the second time because you use more shampoo. But every 5 years is just a guide. It could be every 10 years, but it shouldn't be longer than that. I mean, it really should be something to look at because it's kind of like the individual who filed the benefit plan when they started working for the government and haven't looked at it in 20 years, and obviously things have changed. And that's the only thing we're asking you to do is periodically, we're not saying come in and see a lawyer. What we're saying is every 5 years, take the document out, read it again, and see if it's what you want. If it is, put it back, put it back wherever you have a copy. If it isn't, then maybe it's time to start making some changes. And if you see things in publications about it in the Washington Post or online or something, that things have changed, they made major changes, then clearly you'd want to do that. For example, in Maryland, a lot of people have a trust that's specifically set up to deal with that $1 million exemption. If Maryland does do away with their state inheritance tax in 2019, you may no longer need that, and you may want to eliminate that from your state. Yes, sir.
What happens if you have a will that's written when you were relatively recently, but you were a resident of a different state? You have property in that state, but now you're a resident in Virginia or DC. Do you need to take a really close look at that?
Yeah, it's between a lot of the states, there's probably not huge. Our advice, if you're asking us lawyers, is always to have it reviewed by somebody in the state just to make sure it's not a problem. I'll tell you the ones that'll trigger an automatic review. If you move to Louisiana, you're going to have your will reviewed because they're under Napoleonic law, historically, not common law. So that one you have to do. There are 13 states in the West that are under a community property law. It comes out of the Spanish tradition. Well, actually, there's 12 states plus Wisconsin. I don't know how Wisconsin adopted that, but they did. But it's Texas, New Mexico, Arizona, California. It's kind of like the border states and Nevada and some others. In those states, there's different presumptions on ownership of assets and that. So if you're moving to one of those states or you have moved from one of those states, it is probably important to have your estate plan reviewed by somebody in the state that you're living in. Yes, ma'am.
I'm trying to understand what Virginia resident have been for 25 years. My sisters are my beneficiaries. I don't have children. If Virginia does not have a state tax and does not have inheritance tax, is that good for my estate or is that good for them as inheritors or both?
Both.
Okay. So they will not have to pay an inheritance tax, even though they live in Massachusetts.
I think it is one of the 6 states that have an inheritance tax.
Yeah.
Pennsylvania.
Okay.
Maryland.
So it's the inheritance tax is based on where the beneficiary is living.
California?
I don't think they don't have them.
All right.
It's usually, the basic way to understand it is all the New England states are heavily taxed except for New Hampshire. Live free or die. Yes, sir.
Yeah, just a question on the state, I'm sorry, setting up trust where there has been a great deal of promotion over the last few years. And my understanding is the major benefit is to avoid exorbitant probate costs, but you're saying that in Virginia, the probate costs are very, very low.
There are always reasons to set up trust. I mean, one of the reasons if you're a Supreme Court justice, you don't want to see people see your mistakes, because when it was Rehnquist, when he passed away, his will was probated in the Arlington Circuit Court, and then within 3 or 4 days there were articles in the Washington Post on how he could have saved money on taxes because he'd done this and that. So if it had been a trust, it would not have been recorded. So that situation. Certainly you have a special needs situation, if you have young children, if you're concerned about somebody has had a history of addiction or immaturity or something like that, and you want to control how assets are distributed, there are some very good reasons for trust. However, the need for a trust has been greatly reduced with the adoption of portability and the increase in the exemption amount. The tax reasons for most people will not exist unless their estates are over the 10.68 million, or unless they have some special requirements. So, grandchildren would be a special requirement that it probably would lead to the trust. Another reason would be if you had property that was in another state and you wanted not to have to probate in that state, because if the property's in a trust, then that won't be probated in North Carolina where you have your beach house or you share a beach house with the family or something like that. Yes, ma'am.
So earlier there's a conversation up here that was a little bit confusing about the, if you're in different states and have these different mechanisms to avoid the $1 million cutoff that was, the general regional cutoff. And it's my understanding there's also cutoffs for going to probate as well. Like there might be a $1 million, if you don't make that, then you don't end up in probate either, or at least in some states. I don't know if that's true or not, but she was talking about having it separated in 2 different states, and therefore she didn't make this cutoff. And then another area she went into, we didn't really answer the question, it was kind of confusing. If you have these other mechanisms, like you take the property and you make it two owners with rights of survivorship or something, and then it automatically slips into the ownership of the person without ever having to go into probate, or you have stocks or things where the people are, or accounts where the people are already written as like the co-owner or somehow an automatic beneficiary of those will not go into, this is what I didn't understand about the question and the answer, those will not go into this estate and therefore will not be part of this taxable, probatable estate, or will it?
Let's separate what's in the probate estate and what's in the taxable estate. The probate estate is only things that are in your name. So if there's an automatic transfer because it's joint ownership, it won't go into probate. Okay? If there's a transfer on death deed, if you've got a pay on death designation in a bank account, if it's in a trust, all those situations are going to not be probate situations. But they still could be estate tax situations. So what I think one of the questions the woman in the first row basically had was, she was saying, all right, I've got an asset that's in one state, and we were trying to distinguish between personal property and real property. Real property is always going to be in the state it exists in. Personal property is going to be in the state where you live. Okay? So you could have a situation of having a $1.9 million estate, have $1 million in bank accounts and stocks and annuities that's in Virginia, and a $900,000 account real estate in Maryland, because that was the house you used to live in or something like that. You would not have a Maryland tax because the Maryland asset is only 900,000, not $1 million.
Well, it sounds like if you have properties in two different states and then you find ways to take some of these assets out of it, you could avoid taxation or the state tax, because the situation I'm looking at there is if you have properties in two of those taxable states, which you had up there.
Right, but if you
Yeah.
live in Maryland and you've got your personalty and your house in Maryland, you're not going to avoid it if the total's over $1 million.
Okay.
Yes, sir.
Would it be fair to say from everything I've heard today that DC is one of the most tax-unfriendly jurisdictions in the nation?
No, it's at the lower half.
Yeah.
Okay, it's not at the very bottom, but it's definitely in the, as to the three, Virginia is clearly the less taxing jurisdiction. DC and Maryland are probably about the same. If Maryland goes through, if they're doing away with the state tax, then DC will be the worst in the jurisdiction. But the 31 states that don't have an inheritance tax all have a benefit for inheritance purposes over the other states. I mean, you know, I think there are people who, even though Alaska is one of the most tax advantaged states, that people might not move there simply because of the weather and conditions. So you've got to look at everything. Right now, just to digest, probably the best jurisdiction to live in if you decide to do this and you're not leaving the country. And this group is not likely to have many people interested in leaving the country. But if you're not going to leave the country and you have what I would call mainly liquid assets as opposed to real estate and things like that, you ought to be considering Puerto Rico. Because Puerto Rico last year adopted a 4% tax for U.S. citizens on Puerto Rican income. That is a 20-year agreement between the Commonwealth of Puerto Rico and individuals who move there. And what is happening is they're setting up on the north coast of Puerto Rico the same type of communities that now exist on the west coast of Mexico, where people move down from California, Arizona, and they're English-speaking or bilingual communities. And people live there because the costs are lower. Puerto Rico has the other benefit. There's no U.S. citizenship issues. You basically pay 4% on Puerto Rican income. Now, if you own stocks and bonds of U.S. companies, that's not, the law is very clear, that is not Puerto Rican income, that's American income. But if you were to, if you retired and played the stock market and you bought and sold stocks and you did day trading, for example, that income is capital gains or short or long-term gains. And that is considered Puerto Rican income because you're living there. That's the situs of your income. So you are going, if you start hearing at the cocktail parties about people moving to Puerto Rico, there's probably a reason. I'm not saying they're going to, but we did an article on this. I had a law clerk do an article. We just put it in. We thought it was kind of interesting for our clients. We doubted very few of them would be interested, but I got 3 calls from Puerto Rican law firms and 2 calls, one from the New York Economic Development Commission of Puerto Rico, the one in New York, and one from San Juan. And they wanted to know if there's anything they could do to help us. And I am sure that it's just like, I mean, if people now move to Florida from Maryland particularly, or DC, to avoid inheritance tax and income tax. At this point in time, if you have no federal income tax and you're only paying a 4% Puerto Rican tax, I think you're going to see people that qualify. It's a very small group that are going to qualify because it's got to be Puerto Rican-based income. If you own real property in the U.S., you're still going to pay the regular tax. If you own stocks in U.S. corporations, but If you own stocks in Barclays, I mean, if a foreign company has over a certain percentage of assets in the U.S., it's considered U.S. under the Puerto Rican statute. But there's no reason, there's no getting around why Puerto Rico did this. They want to bring high wealth individuals into the country, you know, under the same theory that the small states are doing. Some money is better than no money in terms of taxes. Plus, if they live down there, even if they live there 185 days a year, they're going to create jobs for building the houses and, you know, running the yacht clubs or whatever they're going to be doing.
Do they tax federal annuities?
What?
Do they tax federal annuities in Puerto Rico?
Probably, yes, I would think that would be U.S. source income.
What are the tax, if you could review the tax implications of gifting, both for the giver and the recipients?
Usually for the recipients, there's, except for in 6 states, there's no implications whatsoever on that, okay? So it's really, you're looking at the person who's giving the gift. If you're eligible for the annual exclusion amount of the 14 or 28, depending on whether you're married, nothing happens. If you're giving 100,000 and your exemption amount is 28, okay, then you basically have 72,000 that you are deferring paying taxes on. You file a gift tax return, it will reduce the amount of your credit of debt by 72,000, but it has no immediate implication in terms, you're not paying taxes on it right away. So it's only when you go over 5.34 million, and most of us like that in a problem.
Could you explain a little bit appreciating stock? For instance, I inherited stock upon my parents' death, and so I know what that cost basis is. If I want to gift that to my daughter, am I limited to $14,000 worth of stock in a given year? And is my cost basis at that point her cost basis?
Yes and yes. You are limited to the 14 in terms of a gift, but if your estate is under 5.34 million, what difference does it make? Okay, I mean, if you have to file a gift tax return, because you're never going to use it up anyway. But from another point of view, it would be.
So there's a form I have to file whether I give cash or stock, and it's only if it's over the 14, or
Yeah, only if it's over the 14. And quite honestly, if it's $14,003, use your own judgment.
Yeah.
But if it's 20,000,
I could
yes,
gift
you
her
definitely.
$14,000 worth of stock right now, and there's no forms that either of us have to fill out, there's no taxes.
Right.
And we just declare the cost basis for her.
She's going to, if you gift it to her, she's going to take your cost basis.
My current cost basis, okay.
Now, another strategy that you might want to consider, okay? And again, I'm now sounding like I'm in favor of aversions and all these other things, but the Supreme Court has made it very clear that we're all entitled to take every deduction that we're entitled to. Okay? One of the things you could do is if you had stock that was worth 40,000, okay, because that is your amount now, okay? You could either potentially give her part of that and sell her this all depends on what your tax bracket is, because you would have income. Or the other way is you could give her that gift, okay? And if she sells it, she is going to sell it in your lower tax basis. But for some people, they're in the 0 to 10% tax bracket when they sell it, so they're not going to have taxes. So even though you're going to use up part of your gift tax exclusion, it still might make sense, because if you sold it, you would be paying taxes on your rate and then turning over the money. So giving appreciated stock can be a value. Now, the other way it can be a real value is if you're giving a gift to somebody, to a charity or something, because they're going to you're going to get the value of the stock at that time. You're not going to pay the cash on the income. I mean, let's say you had GE shares and your basis was $10 and now it's 26 or something like that. So you would basically, if you gave that to charity, you get the deduction based on the $26 a share. They go out and sell it, they don't have any income from it because they're just selling it. But you don't, if you sold it yourself and then turned around and gave them money, you would have income between the 10 and the 26. So you definitely want to avoid that. Yes, sir.
I don't know if you talked about life insurance. I was reading recently that there's an alternative to the FEGLI for those of us who are active duty still, active service. Is there an advantage to FEGLI over this, what is it, AEFA or something.org? I think I was looking at their website. They say they're much cheaper and it's the same deal, and FEGLI seems like it's a benefit that comes with employment, so you should stick with it. I'm hesitant to just give that up and switch entirely.
You know, I don't feel comfortable in answering that question. I don't think I'm qualified to make it because I don't know enough about the various programs to be honest about responding. If there's somebody else in the room who wants to take a shot at it, go ahead.
I think it's like the American Federal Employee Association or something along those lines.
Well, I do know that a number of people, do switch after they leave, they do change their retirement benefits. I never know whether that's good or bad. It really seems to be a case specific. In some cases, it makes a lot of sense. In other cases, it's not as good a deal because of the cost basis of providing running the retirement program or something like that, or insurance. I just don't. I'm sorry. I really don't know enough of the specifics to give a definitive answer.
Just to follow on to that, you were talking earlier about insurance being taxable. I thought there was an exemption for life insurance. Is it only up to a certain amount, or? You were talking about putting it in a trust to protect it and that sort of thing.
If you put it in an irrevocable trust, a life insurance trust, it's not taxed because it's not owned by your estate. But otherwise, it's a taxable. It is a taxable as part of your estate, just like your house or stocks or bonds. It's an asset that you receive. Now, if it's owned by somebody else, it's the ownership of the policy, not the beneficiary of the control. So if it's owned by somebody else, if you change the ownership of the policy to a spouse or something like that, then your death is not Matruder's. It's not your policy. So that may be what they're talking about.
You're saying that the benefit to the beneficiary is not taxable, but if the policy is...
Yeah, that is correct. The benefits to the beneficiary is not taxable, but if the policy is owned by the decedent, it is in the, what?
No, go ahead.
Yeah, it's in the decedent's estate.
Okay.
And it may or may not be taxable based on the exemption amount and how much the estate is. Thank you all very much.
Thank you.